right, well, I guess it's probably okay to get started. I wanted to certainly thank you for indulging me to come out and do a little bit of ethics training, as we like to call it. But for those of you who I haven't met, which is most of you, my name is Yvonne Navarez-Goodson. I'm currently serving as the Executive Director of the Nevada Commission on Ethics. And I've been with the Commission now almost 8 years. When I started with the Commission, I started as Commission Counsel and came from there from the legislature. So I have a background at the legislature and then in some private practice for a few years and then back into government, mostly with the Commission. So I'm pretty familiar with the circumstances you all find yourselves in as public employees and public officers. I myself am a public officer subject to the ethics law, so hopefully this dialogue here today can be a little bit interactive. I find sometimes I do these trainings to rather large audiences and then it's me talking at them, you know, for an hour or more and the eyes glaze over and get sleepy. So in this instance, we have an opportunity to have some dialogue. If you have questions or want to embellish on a couple of areas because you have questions or circumstances that might be unique to Boulder City, I'd be happy to kind of talk about those issues with you today. And then I also know most of you have maybe sat through some of the trainings that either NACA or Nevada League of Cities has provided, and that's really a great resource for the Commission because it is difficult for us to get out into the communities as much as we would like. But in this instance, with my experience, I can probably give you the nitty-gritty about some of the decisions of the Commission and where the Commission, I think, the direction that they're going. I think one of the things that's unique about our Commission in today's world is that it's a whole new Commission. So our veterans have all termed out. We have basically an entirely new Commission. We've had a lot of vacancies over the last year that have been filled and left and filled again. So we're looking at some revitalization at this point on our Commission. So I'm going to be curious to kind of see what direction the new Commission will be going in. And we've also put together this year for this session, we'll see how it goes, a pretty progressive bill, I think. The Commission has finally found itself in a position where it's wanted to revamp our procedures pretty significantly, primarily with regard to third-party cases, complaint cases that come forward. The Commission's real mission is outreach and education instead of adjudication and enforcement. And I think our enforcement arm will always be there for those cases where we're seeing, you know, true corruption and things like that in government. But in other circumstances where we're seeing issues that involve minor violations of the ethics law, we're hoping that we can resolve some of those circumstances more, probably what I would call administratively. We'll have deferred actions. We'll have education as an opportunity to cure or mitigate ethics violations, unless we're seeing situations in which there's a real willful or bad faith effort to sort of get away with breaking the law, and those are rare. Those are the exceptions, certainly, not really the rule as far as what we're seeing across the board. So I encourage you all, and I'll talk a little bit about that today, our bill that's going to be going forward in that effort. And I obviously encourage not only those of you who are going to be subject to it, but your council. We're trying to get some local government input on that bill before we hit the legislature, just so that we're knowing, you know, if we're going to be treading on some uncareful ground unknowingly, then we'd like that feedback as we go into the legislature. So in that vein, I don't know how many of you are terribly familiar with the ethics in government law or the Commission on Ethics, but we really have jurisdiction over a pretty limited area of law, and that's NRS 281A. A lot of people think we have jurisdiction over open meeting law and public records and lobbyists and campaign finance, and really all of those issues are other agencies within the state. It's either the Attorney General's office or the Nevada Secretary of State and things like that. But what the ethics in government law is geared towards specifically is conflicts of interest. And so when we get into understanding what is a conflict of interest and what is ethics in government law, I often get the questions posed at me more by the public as opposed to those in your situation. But a lot of members of the public will say, you guys are the morality police. And ultimately, I think there is certainly a component of ethics in government law that triggers morality issues, but ultimately, the ethics in government law is a series of statutes that govern conflicts of interest. And so sometimes what is legal is not always ethical, and what is ethical is not always legal under the ethics in government law. And so when I talk about ethics and the principles of ethics, what I'm really talking about primarily under the law are conflicts of interest. And so the legislature has sort of defined that for us. What's a conflict of interest that's going to govern your conduct as public employees and public officers? And that's going to be anything that is you're being asked to do in your government position, any decision you're being asked to make, whether it's voting on an issue on an agenda item, all the way down to approving an application for a license or grant money or whatever it might be in any of your official capacities. If you're being asked to do that and that has the potential to affect a personal interest, then you probably have a conflict of interest. And so one of the things I like to make clear to public officers and employees is that the legislature, the Ethics Commission, and the ethics in government law is not saying you can't have a conflict of interest. It's saying we understand as citizen legislators all the way down to our local governments that there are business interests and professional affiliations, familial interests, and things of that nature that are going to affect our public officers and public employees. And so we just want to be in a position where you recognize when the conflict exists, and then we have a series of rules that govern what you can do when you are confronted with those conflicts. And some of them might be so significant that it warrants an abstention on your part. And abstention trickles all the way down in some sense to our public employees. And so we look at that differently than abstaining from a vote for the members of our city council. But if we're public employees who are making decisions on various issues, then abstention might very well be that the conflict is so significant that the issue that you're being asked to decide needs to be delegated appropriately and likely disclosed to your supervisor. And that's how we deal with that on the public employee level. But ultimately, a conflict of interest, again, is a public issue, public decision you're being asked to make that's in conflict with a personal interest. And so the obvious question then becomes, well, what are the types of personal interests that are triggered under the ethics law? And so really there are two main issues. I think I'm on camera, and I know you have the PowerPoint in front of you, so I'm going to kind of sneak through that a little bit. What I wanted to talk about really are the various types of personal interests that trigger ethics in government law at all, and then we'll get into the types of prohibited conduct. So the first one is the most tangible type of personal interest, and it's really usually easily targeted by public officers and public employees. And those are the types of personal interests that trigger a financial interest for you. And so when we talk about financial interest, it can be a positive financial interest or a detriment to your bottom line. And so usually we know if we're being asked to make a decision that has the potential to affect our financial interests in one way or another, that's tangible. We can usually pick that out, and sometimes not, because of the nature of business interests and things like that are rather sophisticated and varied in today's world. But ultimately, for the most part, you're going to know if you're being asked to make a decision that affects your financial interest one way or another. And one thing that the ethics law looked at, I think as early as 2011 or 2013, was the statute used to just say a pecuniary interest. And we would get things where it would be cents on the dollar in a very minor way, triggering ethics violations. And the commission said, we really want this to be a significant pecuniary interest. And so you might ask, well, then what's a significant pecuniary interest? And the reality is that depends on the issue that's before you, because the way the ethics law is written, it talks about having a significant pecuniary interest in the matter that's under consideration. And so you really have to look at what's being decided to figure out if that's triggering a significant financial interest. And so again, that can be very sophisticated depending on the business of the city and what issues are before you. And so I don't have a direct answer about what's significant, but ultimately we ask you to kind of consider what's being asked, and if it's a significant pecuniary interest, it's going to trigger conflict under the law. Now, Most oftentimes I'm going to tell you if it's triggering a pecuniary interest at all, it's probably worth stopping, making a disclosure either to the public or to your supervisors, at least getting some feedback, ideally talking to your city attorney about those issues, because they're going to be in a position to be able to guide you about whether or not continuing to act on a matter is appropriate. So in addition to our pecuniary interests, we have this whole body of law under statute, and I laugh sometimes because the terminology that's used in statute is very cumbersome, and because a long time ago in my early career I was a drafter of statutes, and I thought I would never have gotten away with using this terminology, but someone somehow did, and it's called a commitment in a private capacity to the interests of another person. And so I think that terminology, the reason that it's confusing is because it creates this whole host of circumstances in which the legislature has decided for us that we have relationships with certain persons that are so close and personal in nature that the law is going to statutorily attribute their interests to become your private interests. And so where this gets somewhat confusing is because you might be able to say, okay, well, if my spouse is sitting before me requesting whatever it might be, a grant application on behalf of a nonprofit, I can be objective because I serve the community and I want all nonprofits to be successful in this community, so I can be objective. Well, the law is going to step in and say, no, you can't. It happens to affect the interests of your spouse, and by law, a spouse is one of those relationships that triggers a conflict. And so under this definition, we know that persons that are within your family within the third degree of consanguinity, another great term of art that we use in our statutes, is going to be deemed to be a conflict. And so what's the third degree? We know it's, for most of us, it's going to be our parents, our siblings, our children, our grandparents, things like that, our grandchildren. It's not going to be your second cousin twice removed. But it could be. And the reason that it could be, that type of relationship could be triggered under the statute, is because we have this other category of relationships that are substantially similar to familial relationships. And so we get a lot of questions. You know, if the legislature had directed or demanded that public officers abstain every time an issue affected a friend of theirs, Nevada would come to a screeching halt, right? In any community, not just Nevada. And so we know that friends and acquaintances and, certain relatives might not trigger the absolute conflict. But if the facts coming back to me suggest that your second cousin twice removed might have grown up in your household and was treated like a sibling and you were raised with them, all of those kinds of facts and circumstances that might be relevant to a determination about how close that relationship is are going to trigger that other provision of statute that's a substantially similar relationship. And so, again, we know that it's our family members within the third degree. We know it's our business affiliates and business partners. We know that it's our employers, and that can include our public employers. And so if you're being asked to do something that affects your employer, even in your public capacity, to benefit your private interest, that could potentially be a conflict of interest. And then finally, persons who who live in our household and who are also related to us within that third degree are going to qualify. So I'm going to spend just a little bit more time on this idea of commitments in a private capacity, because this is sort of the issue that we see most often. And it's this idea of business relationships, particularly in the state of Nevada, because business relationships are very diverse and they're very sophisticated, and you might have a business relationship with one person, and that individual could likely have 100 business enterprises outside of yours. And what the commission has come in repeatedly and said is that it's the relationship itself that's triggering the conflict, not the business interest. And so in that vein, if you have a situation where you might have a business affiliation with Joe Black, for example, and Joe Black has 13 other businesses outside of your business connection, and Joe Black comes before the city council on one of these other unrelated business enterprises for a zoning variant, whatever it might be, before the city council. It's because you have a relationship with Joe Black in one business capacity, it's that relationship itself that's triggering the conflict. And so even though you can sit there and say that you don't have any interest whatsoever in the business that's coming before you, it's the relationship that causes the conflict of interest. And so that at that point in time, we're going to ask you to evaluate the issue even further. And so keep in mind that the law talks about, when it talks about our own interests, it talks about financial interests primarily. But when it talks about a commitment in the private capacity to the interests of another person, it doesn't specify that it's a financial interest. Now, most often in a business context, it's going to be financial, but interests of another person can be very various. And not just financial or not just business related. And so you really have to get a little bit broader in your thinking about these types of conflicts when they come before you, when there are interests that affect people with whom you have these relationships. And so one example I might give, sometimes the absurd sort of draws the point, with some of these ethics examples, if you will. But if I was serving as a member of a city council, for example, and say my husband was a volunteer for a couple hours every Saturday at the Humane Society. He helped with pet adoptions, for example, or something with the Humane Society. And all of a sudden, I have a grant application before me on behalf of the Humane Society for money. And everybody in the community happens to know that my husband volunteers, a couple hours every month at the Humane Society. Well, if I don't disclose that issue to the public, they're waiting, right, in the background. I'm going to get you, I'm going to file that complaint because I happen to know her husband works for the Humane Society, and now she's voting on something that could potentially affect his interest in the Humane Society. Well, the reality is when we get into disclosure and abstention, the better your disclosure is, the better you work yourself into or out of an abstention. And so in this instance, I might say to the members of the public, okay, well, my husband actually volunteers a couple hours of his time once a month to the Humane Society, but he's not employed. He doesn't make any money. His interests don't stand to be benefited. His volunteer time's not going to be affected by this grant application. Or maybe it is, but you want to go into some sort of level of detail about how it is that your ability to vote on this grant application is going to affect the interests of the person who's before you. Now, it might be an entirely different situation if my husband was employed by the Humane Society and this grant application was going to be critical to maintain his position with the Humane Society. And so all those nuances and that level of detail can help me decide whether or not it's appropriate that it's so remote, the interests aren't materially affected, that I can go ahead and vote on it. But because I'm disclosing that to the public and informing them of the full nature and extent of my conflict, they're being informed I really don't have a conflict that precludes me from voting in this instance, but I'm simply disclosing this affiliation, versus, again, in the second instance where my husband is employed there and his pay is probably critical to this grant, then I'm sort of telling the public, I'm signaling to them, you know what, it's really not appropriate for me to vote on this because ultimately my husband's job is on the line for this money. And do you see where kind of the distinctions can come into disclosure and abstention in that way? And so that's sort of kind of the biggest pitfall that we see with disclosure and abstention, is sort of these cursory disclosures from public officers and public employees, quite frankly, where there's not enough information about the nature of the issue that's really being affected. And so then we kind of get in trouble when we're trying to explain to a public officer or a public employee what a reasonable conflict is versus what a material conflict is. And because it's so fact dependent and so circumstantial to the issues and the types of relationships, it's very difficult for us to have a black and white rule on disclosure and abstention. And so that's where we come into play. We're always available for phone calls and those types of issues. But our first line of defense, and we always ask that you please rely on the attorney, not your private attorneys, but the attorneys who are publicly appointed or elected to serve your agency, because we do have provisions in the ethics law that protect public officers from willful violations against the ethics and government law. For good faith reliance on that counsel. Now, there was a period of time, probably prior to 2013, where we were seeing situations where, and I think any public attorney can appreciate this, it's inevitable that 2 minutes before the meeting, you're going to get that phone call. Hey, I see this agenda item. I might have a conflict. What should I do here? And you have to be fair to your attorney, too. You have to give your attorney as much information as possible for them to be able to give you reasonable advice in those types of circumstances. And so certainly there's no prohibition against talking to your attorney 2 minutes before an agenda item. I mean, that's reality, and we know those types of things happen. But really just be cognizant of those issues when you're looking at significant conflicts of interest, because the whole goal is we're avoiding conflicts, we're avoiding complaints being filed, we're trying to garner outreach as opposed to, adjudication, if you will. So that's kind of an overview of the types of conflicts that the ethics law, or the types of personal interests that the ethics law triggers, a little bit of an overview of disclosure and abstention. And then we have this whole slew of other statutes that really govern misuses of position and gifts and things like that. And I wanted to spend a little bit of time on those issues. But before we jump into kind of the thou shalt nots under the ethics law, I wanted to spend a little bit of time, if you have questions about disclosure and abstention or any possible unique circumstances that you wanted to kind of bring to my attention, we can talk through. Is there anybody that has any of those types of issues?
Got lots of questions.
Okay.
I don't know.
It's at your pleasure. Certainly.
All right. So with abstention, it seems like the message that's always been in the ethics law is that as a public officer, you have a duty to vote whenever possible. But with all of the pitfalls and ambiguities, what's significant, what's not significant, those types of things. People just out there looking for gotcha moments. Right. It seems like the message that's being sent today by the Ethics Commission is, err on the side of caution and abstain whenever there's any kind of doubt at all. So how do you respond to that? How do you balance that?
Sure. Well, I certainly don't want to imply, and if I did, I apologize, that abstention is the better course, because as you know, there is a very fine balancing act. And so the one thing, that we caution against this, attitude of abstention is you're right, that the legislature has been express in our statutes about the fact that you guys are in a really challenging position. You're elected by the citizens of the city to make the tough decisions, to vote on issues that are sometimes controversial and sometimes tough. And if you're not voting, you're taking away their representative voice in government, right? And so the legislature looks at that very seriously. And so, again, it adds this caveat, right, that only in those clear cases do we want you to abstain. And so that's where the Ethics Commission gets hung up a little bit sometimes, is because, there are so many different various facts and circumstances that are presented to us. And so I could probably tell you that I have a clear line in certain instances where I'm probably going to always advise you to abstain. But sometimes I'm really looking at how material the effect on your financial interests or the interests of those persons to whom you're related, how material is that on the decision you're being asked to make? And so that's where we have some balancing. And so where it involves a business interest, a person who has a business affiliation, a relationship with you, even if it's an outside business affiliation, the Commission's been pretty clear, abstain from voting on that issue. It's too close, typically. Now, if you can present a circumstance contrary to those opinions where it's saying, okay, well, even the business interest that's going to affect my business partner on the issue I'm voting on is remote, the interest there that they might be affected in is remote, then I'm going to probably say, okay, you're getting farther and farther away from the need to abstain from voting. And so, more directly to answer your question, I think that it is a tricky balance, and I don't want to encourage public officers to be abstaining as a matter of course, because of certainly we need you guys to make those decisions and we need you to represent your constituents, but it's inappropriate to be making those votes. It really does affect your bottom line in one way, either as a benefit or a detriment, or if it really does have the effect of benefiting or not someone with whom you have these relationships. And so, I think that's where the commission, and where I think the commission is going with this bill, is trying to say, we understand that these are sometimes confusing issues, and so we don't want to be tackling all of these issues from a third-party complaint circumstance as opposed to an education and outreach, a deferral order, an explain the circumstances kind of thing to us. But ultimately, I'm not trying to send the message that abstention is the better course, only in those circumstances where it is a clear conflict of interest. And that's where we ask you to talk to your city attorneys, talk to the Ethics Commission, get that advice up front. And if it's a really significant, meaningful issue for the city, and number one, if it can't wait, try to get to us as soon as possible, and we can usually try to get together a commission teleconference, even if it doesn't fall in line with our meeting schedule. But secondly, we might ask you, if it's nothing that's urgent, maybe it could be tabled until there's an opportunity to get those issues resolved, either internally with your city attorney or with the Ethics Commission. So I don't know if that really answered your question, but ultimately I'm not trying to encourage abstention as the better course. It's certainly the more conservative approach. It's going to save a lot of folks from, complaints being filed. But what I will say, as a notable statistic for the commission, at least over the last 2 fiscal years, is that there's a lot of feedback that we're sort of used as this pawn for ethics complaints. And while we receive probably approximately anywhere from 70 to 90 complaints a year, we're actually only accepting and investigating about 20 of those. And so we are weeding out a lot of the types of complaints that people think are just being used as, pawns, because we see that those issues are there, or maybe there was an appropriate disclosure. And then under this sort of bifurcated process, a lot of times we'll get halfway through and we'll get into an investigation, we'll realize the information we had up front simply wasn't accurate, and we'll be able to dismiss it early on. And so, again, I don't know that really gives you all the best clarity that you were hoping for, but ultimately not trying to encourage abstention, but only in those circumstances where it's direct and clear under both the ethics law and commission opinions.
All right, thanks. And, I'm glad that there's some kind of movement towards education and outreach versus enforcement. Yeah. But I mean, even with all the fuzzy, nebulous gray area there, even just getting a complaint filed against you and going through the process, that gets out to the paper, even if it's a non-willful violation at the end or no violation, you get dragged through the mud in the process. And so is there any kind of effort to, will there ever be any consequences for predatory people out there just looking for the gotcha moments? Or because there's consequences on the public official side, but there seems to be no consequences on the public side, whether it's valid or not valid, frivolous type of complaints.
Sure. Well, I can honestly say the commission has been tackling this issue for at least the last 3 sessions that I've been a part of. The first issue is that there, prior to my tenure, there was a statute, in fact, in the Ethics Commission that made it, I don't know if it was a violation or if the commission could impose sanctions against what they called a vexatious or bad faith complainant, if you will, someone who was bringing things for political reasons or, ultimate bad faith. And that was deemed to be unconstitutional because it was punishing someone for bringing forward a complaint, essentially. And so then the commission that statute got removed from our provisions because of the theory that somehow we were infringing on the First Amendment rights of someone to bring a complaint and say whatever they wanted to say. And ultimately the process should take care of that type of thing. And the second issue that the commission is seeing, quite frankly, is that, 95% of the issues that the commission is investigating from a complaint point of view are relatively minor violations of the ethics in government law, right? These aren't circumstances of corruption or bad faith or intent to steal or bribes. And if it's getting to that level, I mean, certainly we can have an ethics review of it, but if it's getting to those types of levels, it's also crossing into criminal context, and we're going to refer a lot of those issues out. And so when we look at things from an ethics point of view, in government, the majority of people that tend to have information about true bad faith goings on, if you will, in government are the people who work in government, and they're too afraid to bring those issues forward for fear of retribution and retaliation and those types of things. And so last session, the commission sort of proposed this idea of anonymous complaints, and not because we wanted to be able to, take anything and everything, because the caveat was always going to be we were going to have this evidentiary component to ever accept a complaint. And that exists in the law today, and that was going to continue to exist. And the legislature was uncomfortable going that far, but instead they sort of compromised, and they came up with, if someone wants to bring a complaint within their own agency, they can request that their name remain confidential from the requester. And so, ironically, we did a big push for that, and we've seen one complaint since 2015, because the fear is that those public employees still aren't feeling that secure. And so so then the commission has asked the legislature, well, the pitfall in the law is really that under statute, we are required to keep a complaint confidential, and we will not confirm nor deny the existence of a complaint. And the reality is, there's a lot of media reports out there that the Ethics Commission is investigating something, and the truth is, we're not. We may have received a complaint, we may have dismissed it outright, but people just will never know because we can't confirm or deny those circumstances. And so we asked the legislature, what is our opportunity here? If we're statutorily required to maintain the confidentiality to preserve and protect those public officers in those situations and public employees, then how do we control the inevitable release of documentation that the requester might give to the public? And the answer that the legislature has given us, frankly, is we can't. That's just an infringement on First Amendment. Every similar body, the Judicial Discipline Commission, confronts the same issue. And we've looked at other ethics commissions across the board, and everybody is sort of confronted with this issue, quite frankly. Now, one thing I have seen happen is that it can be grounds for dismissal of a complaint. But sometimes that infringes on public policy issues, right? If we're just going to dismiss a complaint because someone publicized it, if there's truly an ethics violation going on, then how did we dismiss it? And then, frankly, the only other way we can control it is to initiate the complaints on our own motion, and then nobody would know about it, right? Because then it's just kept in-house in its entirety. And so we're playing around with those types of issues. Number one, if there's an avenue for us to statutorily be able to dismiss a complaint if the requester goes public with it. Secondly, if it's dismissing a complaint and then bringing it on our own motion to cause an investigation, and then there's no confirmation about that. Those are the only two ways we've come up with to sort of protect the identity of a public officer or public employee through the course of a complaint proceeding. So I apologize, but we've just hit roadblocks on that very issue. And it's not unique to the Nevada Ethics Commission. It's not unique to our agency in particular in Nevada. It's just sort of how the law receives that type of information. So.
All right. Well, I appreciate that. From a public official's perspective, the more bright line rules you have, the better.
Sure.
I really believe that, 99.99% of the public officials out there are trying to do the right thing. They want to know what the rule is, and they want to comply with it.
Yeah, that's been my experience.
It's just hard to know sometimes. So the more you can gravitate that way. Let me dial in just on some issues that are maybe unique to me. Because I'm an attorney, so my question is it ever okay to represent a client whose interests may be adverse to the body you represent? Even if you will never deliberate or vote on that particular matter?
Well, that's an interesting question, because I think what that question is asking is sort of whether or not you have a commitment to your own public body, when you're confronted with diverse issues. And so,
I mean, it doesn't, obviously the statute itself doesn't directly say you can. And there was a time, this is the pendulum swinging again, back in the 90s at least, probably into the 2000s, where the Ethics Commission was, saying it was okay to do that as long as the distance was big enough. Now it seems like, and that's why I'm asking the question. I don't know if you guys taken that bright line stance, but is it ever okay? It seems like the answer is no now.
Well, I have to be honest, I'm not familiar with any sort of bright line stance on that with respect to attorneys and their representation of private clients that might be adverse to issues that are under consideration by the body. Now, the more direct implication, right, would be if your client was appearing before the city council for an issue, adverse or not. That's the client. It's the relationship itself and that person before the body seeking something that you might be able to accomplish in your official capacity. That's what creates that conflict. But I think what you're asking, and we do have an opinion that's somewhat unique, and again, didn't come up with a bright line rule, and in fact, in some respects, it dodged that question. But we had a circumstance in which it was a county debt management type of committee. And so the membership of which involved, representatives from the municipalities and the county and the general improvement districts. And that was created by statute. And so the question then became, if this debt management committee was responsible for approving various debts on behalf of the general improvement districts, and one of those debts happened to be from the jurisdiction of the representative from that general improvement district, was that a conflict, and was that member who was the affiliated general improvement district representative, was he out because it happened to affect his district? And the commission said in that instance, based on those facts, no, because it was essentially asking the question, do you have a private commitment to the public body you serve? Right? Does that create a private commitment for you? The commission went back and forth on this from, sort of a public policy perspective, which is, it's kind of crazy to think that a public officer wouldn't have a private commitment to the public body he serves, because he or she is putting himself out there to run a campaign, to do all of those kinds of things. But when you're acting in your official capacity, that's not a private interest. And so that's where the commission stopped short of saying that's an absolute conflict. And that's sort of the closest thing I'm thinking that we have on that issue, which is, no, that's not a conflict, and it's going to be only direct when the interests of that client are before the city council for some decision in some way, whether adverse to the city council or not. It's only when you're being asked to do something in your official capacity that creates that conflict, as far as I'm understanding your question.
And so what about the situation where you are being asked to do something in your public capacity, you represent that client on a totally unrelated matter, but you're asking to vote on something that's unrelated?
If that client's interests are before the city council or to be affected in a material way by the decision you're being asked to make, then because of that relationship itself, I would say that's pretty clear. The commission would say that was a conflict.
Okay. And so things like if you represented the client pro bono, you're not making any money off of it, that doesn't necessarily matter? It's
not the financial contribution of the relationship in that instance. It's the attorney-client relationship that would trigger a substantially similar relationship to a business. I think that the commission has come out pretty clear on that. It's not underlying whether it's paid or volunteer service. It's the actual fiduciary relationship between an attorney and one's client that would trigger that.
Okay, so what about the issue of relying on, in our case, the city attorney? Mm-hmm. I heard you hedge in your language there. You said rely on him, but then you said, well, but you at least won't get a willful violation for that. So you still have to get dragged through the mud, and you get a non-willful violation potentially, if that's what it turns out to be, for relying on your city attorney. is there any movement afoot, or will there ever be, where you can absolutely rely on your city attorney? Because that's what he's there for, to advise you on those things. And, I understand he can't advise you on things that he doesn't have full information about. But if you're given the information, it seems like you ought to be able to rely on that. However, it seems like the onus from the Ethics Commission's perspective is back on the public official. You really can't rely on the city attorney.
Well, I think in terms of a movement afoot, it's my hope that our legislative package that we're putting forward is going to actually confront most of those circumstances, because we won't even be getting into the point where we're doing a full-blown investigation of those types of allegations. In fact, they'll be confronted up front with a deferral order, some kind of education, if you do it again, then we'll come get you, kind of thing. But in answer to your question, the safe harbor provision in the law is actually that limited. And so it's only going to protect a public officer from a willful violation of the ethics in government law. And so I think the way the legislature has taken that in the past is that, again, the absurd draws the point usually. And so this is the basis of this example. But if I'm an attorney and I'm representing, my client, and I say, okay, well, it's okay to rob the bank on Tuesday because there's less money in the bank, but if you rob it on Friday, that's a crime. And so my client might very well say, well, my attorney advised me I could rob the bank on Tuesday as long as I didn't do it on Friday. And so shouldn't I be able to rely in good faith on the advice of my attorney? Well, in that instance, again, that's absurd. But any court of law would say, well, that's crazy. You can't rely on bad faith legal advice in that way. That was unreasonable, not based on the law, not based on the precedent of the Ethics Commission. And so that's, I think, the history of that provision, why, it's going to protect you from any indication that you did something with bad faith or intentional disregard for the law because you sought that legal counsel. But it's not always going to protect the public officer from an actual violation, albeit non-willful in that instance. And so I haven't seen an effort by the legislature or by the commission to tackle that to be just absolute reliance on legal counsel, whether that advice is wrong or not. But what I think inherently will happen if this legislative measure passes with support, and I think it will see some support from the legislature, whether we need some amendments or, if we need to clean part of it up, that's one thing. But I think that will confront that issue up front, which is to say, in those situations where there was reliance on counsel, does it even need to be a violation at all? And that's my hope, because I really do think that this commission has a reasonableness approach to some of these things. I mean, it doesn't want to spend its time any more than anybody wants to be drugged through the process to be tackling these types of issues that would be more appropriately resolved through these educational issues or, and quite frankly, I have to tell you, some very nominal issues that come across our desk end up causing a year of our time by the time we get attorneys involved and legal motions filed and all of these things happen, and it's a year to resolve a case where we could have just said, don't do that again. Unless there was some true harm caused to the public by virtue of their actions, then, we've seen a huge, significant amount of state resources being used for relatively nominal issues. So I think the commission's on board with this movement and these types of things, and we're hoping to promote that to the legislature. But again, I haven't seen something specific to overhaul that safe harbor provision in that way.
Okay, thank you. On the subject of disclosure, one of the issues that came up in my recent ethics investigation was matters that I had voted on and not disclosed on that I wasn't aware of because it was buried somewhere in the agenda packet, which can be 500, 1,000 plus pages sometimes. So when those allegations were made, we asked, we took some steps that we think might help that. Sure. And looking for some guidance from you on this. But one of the things was to ask that and these were consent agenda items, so, ministerial things that typically staff is just saying doesn't require deliberation or anything. So we asked that those actually be put on the face of the agenda as much as possible, the parties that are involved, but also a separate conflicts list created that would list, parties that are involved in these matters that are on the agenda. So, again, I wish we could review every page of every document that comes before us, but we get these things, on Thursday, effectively Friday, before the Tuesday when we have to vote on these matters. We barely get time to get briefed on them, let alone actually review everything. So can we rely on a list that's created by our city clerk, for instance, that has a list of the potential conflicts there and not have it imputed to us that we missed something on page 226?
Well, I think there's a danger in that because I think it's perfectly reasonable to rely on a conflicts list, especially when you've put those protocols in place. And I think the commission seriously would consider that, and it would go towards these sort of mitigating factors when we're looking at whether or not there are violations and willful violations of the law. But I think as a matter of principle and policy, consent agenda items are really a problem for the commission because we see a lot of issues come through on a consent agenda where city councils, county commissions, and local bodies are voting on consent agenda items, again, without that direct awareness. And the commission, from the public policy point of view, is coming back and saying, well, if it needs your vote at all, your ratification, your oversight in any way, shape, or form, you're responsible to the public for that. And if it's voting on an issue that ends up having an impact on your personal interests or those with whom you have these relationships, then that can't not be imputed to you, in other words. And so I think that there's a balancing act there, right? You guys are undertaking the steps that you think are the most appropriate to try to identify those issues in which there are conflicts of interest. But that's also then putting an onus on your staff to try to figure out every time you might have a potential conflict or situation. And so when they're obvious, and if you say, okay, to the clerk, here are all my clients as an attorney, anytime any agenda item comes through that has the potential to affect one of these clients, please signal it for me, then that's pretty helpful tool. But if one's missed, do we blame the clerk or do we blame the public officer for actually making the vote on that issue? And so I think that consent agendas are dangerous in that way because sometimes those are hidden issues, and the commission has been clear over and over and over again that consent agenda items are treated the same as regular agenda items. And so ratification is one of those odd things to me, right? If city staff has already, been authorized and expended the money, if the city council says, no, we don't approve that expenditure, but it's already gone through, I often wonder, well, how do you get the money back? What do you do if the expenditure has already been made? So what is the point of a ratification if it can't actually undo what's already been done? And so, I wonder about consent agenda items and the reality of those and how those work. But ultimately, I'm not sure that the commission would be terribly comfortable just giving an absolute freebie on something like that. And it's going to be a reasonableness standard. If there are cases that talk about a reasonable duty to know what your conflicts are. And so again, that's going to be fact dependent. If it's an application that involves, parent company that has 19 subsidiaries and one of those subsidiaries happens to be someone who's related to your cousin or something like that, and there would have been no reasonable way for you to ascertain that, then that's going to probably be something the commission's going to say, okay, well, you obviously couldn't have been in a position trying to benefit that individual if you didn't even know about it. And counter that with the responsibility to, the duty to know in a reasonable instance where certain conflicts might be. And so it would be unreasonable, for example, if it was your spouse's business that were affected and you just didn't know about it, presumably. So my gut tells me that the commission's not going to be, comfortable with a bright line if it's on a list and they didn't catch it, then it shouldn't be imputed to me. I don't think the commission would like that very much.
The issue of disclosure is really important to the people who have the duty and the opportunity to disclose. And sometimes the messages that we get from the Ethics Commission are mixed messages. And I'm going to tell you a story. This story involves our former mayor who owned a hardware store, one of two hardware stores in Boulder City, and a store along with the other store in which city crews and maintenance people would occasionally buy light bulbs and lock washers and small maintenance items.
Sure.
The city has a claims paid list where all of the checks that are written during the course of a month are published in the city materials and brought before the city council. And our former mayor realized at some point that he should probably be disclosing every time there was a claims paid list that had a check in it to his hardware store. Mm-hmm. And he went up to the Ethics Commission and he asked for an advisory opinion. And the opinion was that he was to disclose every time there was a check. And moving forward, every time there was a check to his hardware store, he disclosed. We had a city council member who was an attorney who decided that she wanted to get the mayor. And she went back to the time when the former mayor got on the city council, and she looked at all the claims paid lists and lined up in the minutes all the times when he had disclosed, and she recorded all the times when he forgot to disclose or neglected to disclose, up to the point in time where he got his advisory commission, and she took that to the Ethics Commission, and she got a willful violation charge against him done by the Ethics Commission. So the message is important, and the message is confusing in a situation like that. So what is the purpose of going and getting an advisory opinion if you can go and get nailed having corrected the thing that you asked for the advisory opinion for?
So that's a great question, and I appreciate it so much because I think, that particular issue in and of itself created some heartburn for the commission too, because taking into account that I am not implying in any way, shape, or form that this was the case in that instance, but from a policy perspective, when we're offering advice to a public officer, it's not intended to be a veil of protection against past conduct. And so what I mean by that is that if we have a circumstance in which a public employee or a public officer has violated the ethics law over and over and over again, and then all of a sudden comes to the commission for an advisory opinion about whether or not he should be doing that or if he should have done it in the past, that process coming for an advisory opinion is not protection against past conduct. And so the goal, right, from the Ethics Commission's point of view is we want to advise you about what to do. And if it happens to involve something you might have done in the past, the goal is still you shouldn't have done it that way, do it this way in the future. But what we can't do is we can't prohibit a member of the public from complaining about past conduct. And so from a public policy point of view, and we've seen this in many instances, not just in the instance here in Boulder City, where and more from a malicious point of view, right, where we have seen circumstances in which someone said, oh, if I get to the Ethics Commission first on an advisory opinion, I'm going to get protection from a violation of the law, because ultimately what the commission is not going to do, and it's made a policy decision as long as I've been part of the commission, is that if you come to the commission for advice about a situation and it happens to involve your past conduct, we're not going to, get you, if you will. We're not going to, because it's a confidential proceeding. It's a circumstance in which you can come to the commission, tell everything, get confidential advice, and we're not going to disclose it because the law doesn't allow us to. And we're also, the goal is, right, to advise you how not to do that in the future. So we're not going to take it upon ourselves to initiate a complaint on our own motion. But at the same time, we can't prevent a member of the public who otherwise has information about the same circumstances in the past from bringing that complaint forward. And so our statutes are very strict about how we have to process complaints that come through. And so that's sort of how those circumstances arise. And so I think it's a good public policy. We don't want to chill people from coming forward to to ask us for advice, even if it happens to involve unfortunate past conduct or conduct that otherwise would have been a violation of the ethics law. The commission's not going to say, we gotcha, thanks for coming and admitting, all of your foes, and now we're going to find a violation against you. But the commission counters that usually in its advisory opinions if it relates to past conduct, or if there's a component of that that says, while we advise you of this, we can't protect a member of the public from bringing that issue forward. Now, the unintended consequence of a circumstance like that is where, again, we really have a situation where we've dealt with the issue, we've advised properly, the conduct going forward is going to be improved, and now we have to tackle this complaint on top of all of that, and so now it's like a double, issue where the commission has to expend its resources times two. I'm hoping, again, that our legislative package will resolve any need for something like that. Alternatively, I guess the legislature could say that we cannot provide advice about past conduct, and so it's always going to open the door for those two, different trains. But ultimately, I think in a situation where, if you could imagine, there was a bad faith effort, right, to come to the commission first to get that sort of protection to prevent a complaint from being filed, if you could imagine a different circumstance, that wouldn't be, that would put the commission in a really tacky position to be able to say, if someone came forward and said, I bribed this person and I did all of these kinds of things, and can you give me some advice about why I shouldn't do that in the future? And then the commission's in a position where it's like,
I'm not sure that the mayor's coming for an advisory was a bad faith effort in his part.
No, and that's what I meant to say. I certainly wasn't implying that in any shape or form with regard to that circumstance. I was just trying to draw again on the example of why that would be a challenge for
one of the things
commission.
that we thought was curious about that whole process was that it seemed as though the fact that he had come for an advisory might be considered in whether or not the commission decided to take its time to pursue the other allegations. Because it's a kind of to me, as a public official, and I'm not a lawyer, but as a public official, I think, well, there was a behavior, he got the advice, he corrected the behavior, let's move forward. It's not a serious thing.
Right. And I think the law hamstrings the commission a little bit in that instance. And so that's exactly why the commission would not have, in that circumstances, initiated a complaint on its own motion after providing that advice. But simply, we can't prevent a member of the public from bringing a complaint forward. And the threshold for the commission to investigate a complaint is simply that it's got allegations that fall within 281A. It involves a public officer or public employee, and there's some scintilla of evidence in support of the allegation for us to investigate. And there really is sort of a mandate for us.
Do you have a vetting process or a way of determining what you're going to spend your time on?
Well, yes and no. And so ultimately, I guess that's kind of a loaded question. Yes, we definitely have a vetting process, and those are sort of the three standards that staff looks at when a complaint comes in. And so from our perspective, and this is what ideally will be changing a little bit if our legislative package changes, but ultimately, and by staff, I mean myself and our commission counsel, we vet every complaint that comes through, primarily for jurisdictional purposes. And we have a bifurcated process currently in place. And so what happens is staff reviews it for jurisdiction. If we have jurisdiction and that jurisdiction is not challenged by either the requester or the subject, then it goes directly into the investigatory process. And so a lot of times, as the executive director, I'll have discretion to make various recommendations to what's known as an investigatory panel. And it might be that I'll look at the totality of the circumstances and I'll say, okay, well, technically there's sufficient evidence to warrant a violation, and it's up to the commission to decide. So this two-member panel should or shouldn't be deciding that. They're just deciding the sufficiency of the evidence. Is there enough actual evidence of a violation here? And then we defer that to the commission for its review, and that's when we come up with all sorts of circumstances. The commission might say, let's settle this out, let's stip, whatever we might be doing. But there's those sort of discretionary channels, which is intake, jurisdiction, which honestly, it's not that hard to get past a jurisdictional review if you're a member of the public, because the evidentiary standard at that point in the game is pretty nominal. And then when we get to an investigation, a lot of times what we'll learn in an investigation, so for example, this is the best example I could give. We very well might get a complaint that says public officer didn't disclose his conflict of interest, and attached to it will be the minutes, and the minutes will not reflect a disclosure. But sometimes we know the minutes aren't always as accurate as a recording of a meeting or something like that might be. And so we'll accept jurisdiction and we'll commence the investigation, and when we get through the investigation, we'll either get a recording or we'll get witnesses who say he did disclose that, and we'll dismiss it at that point at the panel. I'll say the evidence that was submitted at the outset didn't support a conclusion of a violation through the investigation, and therefore at the panel it warrants dismissal. That's sort of the easiest case scenario, right, where there's enough to get me to investigate it and to look into it, but then going through this entire process I learn that wasn't really accurate, and so I can dismiss it. Now, what I'm hoping under these new processes is that I can do all that up front before I decide that it needs a formal recommendation for even investigation. And so those are sort of the streamlining processes that I'm hoping to undertake, where if I get a case like that and I want to know, did this public officer actually disclose this, I'm going to pull the recordings from the relevant jurisdiction. I'm going to make sure, do as much upfront sort of review as I can, and then I'm going to bring a recommendation to the commission, the entirety of the commission, getting rid of the panels and saying, upon initial review, this looks like it's sufficient for us to conduct an investigation, and the commission will make that decision rather than staff or rather than the investigatory panel. And so I think it will streamline and cut up all of those issues up front, is my hope.
So back on the issue of something that's buried deep in the materials. So what I'm hearing is the commission's taking the position that just because you can find it, you could have read every page. So they're taking the position that it's reasonable that you could, it's reasonable that you would have found it had you searched everything. I got to tell you that and then you're telling me I can't really rely on the fact that we've asked it to be put on the face of the agenda or on this list of contractors and interested parties. What that's chilling is the people out there that are good people that want to run for public office, and they look at that and they go, why in the heck would I ever want to get involved in that? It's and I'm out there asking people to run for office all the time, and that's real. It's people who say that to me. I can't get involved in that because I can't have my family dragged through that, or I can't have my business dragged through that. It's a big time commitment to start, and it's a volunteer position, and it's supposed to be a part-time position, but it really turns out to be a full-time position. And then on top of that, I have to expose myself to these, you're going to impute that to me because I could have found it, or, whatever other ethics issue there is. And so, I guess that's my message to you as you're going through this legislative process is, I understand you're trying to do your job, and I understand you're hamstrung by whatever the law is at the time, but it's not really good public policy. I don't think any legislator or anybody on the Ethics Commission would say that's a good thing that we're discouraging people from running for office. And so there's got to be some kind of balance there where the pendulum swings back to the middle a little bit. And so I don't know what the answer is. Do you have any better suggestions on better practices that we could do besides just creating this list of contractors and interested parties, or putting it on the face of the consent agenda? Because I'm trying to scratch my head and figure out a better practice, and I think that's part of what this ethics training was for. So what can we do to protect ourselves? And because we want to protect the public too, but we can't disclose what we don't know, and it's just infeasible for us to review everything. There's just, if all I did was as a mayor was come to city council meetings, if that's my only job, I could read every page.
Sure.
But that's not my only job. I'm out there talking to people, getting people to come in for businesses. I'm answering complaints all the time. I'm on all these regional boards. It's nonstop, and it really is a full-time job. So it's not feasible, and I can tell you, it will happen again to me. I'm going to miss something in the future, and so if somebody predatory out there is looking for it, they're going to find it, and they're going to present it to the Ethics Commission, and you're going to impute it to me because it was reasonable that I could have found it because I could have read every page.
Sure.
So what are the better practices?
Yeah, I wish I had a better answer for you than that. I certainly appreciate the feedback because I think, there's this world of we can get stuck in the ethics law and what it says and what we should be doing. And then on the flip side of that, there is the very practical reality of how various jurisdictions operate and what types of issues they're confronting. And so I certainly respect that as an issue, and I think that the Commission does too. And in some respects, that's part of the reason for a push for legislation like this is because the Commission often doesn't at times feel like its hands are a little bit tied in terms of its ability to, deal with these sort of what we would call minor issues, frankly, issues that aren't really truly seeing like this intent to kind of get away with something. And I'll tell you, and I think I have told you, that's very rare circumstance where that kind of conduct is going on. I think that is a good approach. It's not something we're seeing across the jurisdictions to be able to give those sort of conflict notes to your staff to allow them to know, the types of issues that might be coming forward that directly affect you or your business interests.
Well, in this case, it's the other way around. Our staff is creating a list of parties that are involved in the agenda items. So then the onus is on us to at least just look at the list of parties, and then, they're not going to know who my 200 clients are, but I know who my 200 clients are, and I can look at the list and see if one of those is on there.
Yeah. And I think that's a great practice. And I think from a reasonableness perspective, all of those facts are going to be relevant when the Commission is in a position where it's having to look at those issues, right? It's going to say, okay, well, what practices did you have in place? Did you, was it reasonable or unreasonable to have not found that this particular client was going to be affected by this issue? That, in my mind, goes a long way to telling the Commission what it's going to do when it's determining whether or not there's been a violation of the ethics in government law. And so what the Commission doesn't like is this terminology that the public has come up with, which is like a technical violation. In the Commission's mind, there's no such thing as a technical violation. It either is or it isn't, or it's willful or it's not. But a minor violation, under the law, it's a violation, but is it something that's really infringing upon the public's trust in government? And is it really the type of thing that is, materially affecting someone's bottom line or the interests of their client and things of that nature? So, I'm digressing a little bit and not answering your question directly, which is, do I have, suggestions about how to deal with that? I agree that what you have undertaken, number one, is a great first step because I'm not seeing that in every jurisdiction, certainly. I think, again, consent agenda items can be pretty dangerous because we don't know what gets buried in a consent agenda always, or who's affiliated or what goes on. And the best example I have at this, and I'll tell you, it was one of my very first cases on the Commission, and I was blown away by it, happened to be a newly appointed or elected public officer on a hospital board, and it was her very first meeting, and there was a stack of papers, that she got for this meeting, a day or so before the meeting. And on the consent agenda item was a check run of all the checks that had been approved. And one of the checks happened to be a check to her reimbursing her for some professional conference or something that she had attended. And this was a 2-day hearing before the committee. I was just totally blown away that we were calling witnesses in from this jurisdiction and talking to witness after witness about how this woman could have possibly voted on this issue. And I thought, this is a complete disaster. Like, what is going on here? And after all those 2 days of testimony and everything that was undertaken by the Commission at that point in time, the solution was that it was her very first meeting. This was not a violation of the ethics in government law. And going forward, it was to be a consent agenda item, albeit approving a check run, if it happens to involve, and it was a significant check to her, it was in the thousands of dollars. I'm not suggesting it was, $20 reimbursement, but if it's before you for a reason, you owe it to the public to acknowledge that it affects your interests. And so that was the public policy. That's always sort of the public policy issue that's driving the commission's decisions and perspective. But we're trying to respect that there's a practical component, there's a reasonableness that goes along with some of these things when we're trying to take a look at whether there's a violation. And we're also, quite frankly, trying to be sensitive to the fact that issues that might affect Clark County and the city of Las Vegas are going to be certainly different than the issues that are affecting the city of Ely in the way they approach business and those types of things. And so trying to have this universal, same approach across the board doesn't always work depending on what various jurisdictions are seeing. So I don't have a direct, clear answer for you on that. I think that those practices are certainly helpful. I think that the city council members should take a look at what's appropriate to be on a consent agenda item and what types of things fall within the consent agendas that have the potential to trigger conflicts. That's another maybe thing that can be looked at, but.
So was that hospital individual that went before the ethics board found a non-willful violation?
It was non-willful, yes. It was. And so, and keep in mind, and actually this is one of the things that I will credit your former mayor for, is prior to 2011 or 2013, I'm not sure which date, the commission was absolutely hamstrung on a strict liability standard. If you committed a violation, it was willful under the standard of the law, because the law defines a willful violation as knowing and intentional. And the entire case law in Nevada that defines knowing and intentional doesn't mean you knowingly violated the law. It doesn't mean intentional, didn't mean with malice or disregard or bad faith. It meant that you knew you were going to press the send button and you pressed it on that email. And so the commission found itself in a situation where virtually every violation of the ethics law under statute was willful, unless you could prove, you accidentally sat on your keyboard and the send button got hit and it was not deliberate, And so that was one of the issues that the commission confronted with your former mayor, quite frankly. And out of that circumstance came legislation that following year that put into the law various mitigating factors that the commission could apply to assertions of willfulness, right? Number one, reliance on your legal counsel, which has always been part of the law. But, was there a direct financial benefit? Was this a first violation? All of these types of things. Was it reasonable? Was there really an infringement on the public's trust by virtue of this conduct? And so we saw a trend go from everything was a willful violation to virtually nothing was a willful violation, unless we could prove that sort of component of reckless disregard for the law or, absurdity or something like that. So, in fact, I do credit your former mayor with that sort of change in the law for the commission.
So the distinction between willful and non-willful is still problematic, I think. The public doesn't really see any distinction between them. It's a violation, and in some respects, that's what I've heard today is, there's no such thing as a minor violation or a technical violation from the commission's perspective. When I went through this process recently, the investigators repeatedly told me, it's minor, it's not egregious, and yet I still, end up having to do a stipulated agreement where I consent to a non-willful violation, and so there's got to be somewhere in the process where it doesn't even get to that point, because the public doesn't differentiate, and you still get dragged through the mud. So somehow we need to weed out some of these cases early in the process where you can just say, we're not proceeding with this, or we can dismiss this after a short investigation without having to feel like we have to impose a non-willful, and if you don't agree to a non-willful, then you're going to go for a full hearing. And that's, anyway, I think you understand. And that's something that, from public officials' perspective, but also just from somebody thinking about running for office, they say, I'm not going to touch that with a 10-foot pole. On the subject of disclosure, can you speak to what's a sufficient disclosure, what types of things we need to disclose, and then also to the subject of what if you don't know details, and are you going to impute to us the fact that we had some kind of duty to go investigate this in advance and find out the details so that we could disclose them, or can we just rely on what we know at the time and disclose what we know at the time?
Sure. So first, I just want to say I think you're going to be a huge proponent of this bill the Commission's pushing forward, because I think it does tackle a lot of those issues wherein I don't think that we will see, quite frankly, even a third of our investigations get to the point where they get at this point in time. I think that they will be addressed upfront by the Commission. I think public officers and public employees will cooperate directly upfront. Yep, I blew it. I didn't do that. Because they'll know that the consequence at the end of that is just going to be, okay, here's, a deferral order, or here's something that says, okay, well, here's the lesson there. If you do it again, then we might investigate and have to go forward, and those types of things. So I just wanted to kind of, I certainly would welcome your input, not only as a public officer, but also as an attorney, because I think that input is valuable to the Commission. So I think that there is an effort afoot to sort of confront some of these less concerning types of issues. Now, we always are going to counter that with the public policy, right? We want to be protecting members of the public from self-interest, right? Public officers who are in a situation where they could be self-interested, or they could be voting on things without, being aware of that issue. So, I always counter anything I say with that kind of public policy directive in the back of my mind, right? Is there is a reason for ethics in government law. There is a reason for, ensuring the public's trust in government, because really the public does not have the same ability or access to the information that we're being asked to decide on. And so it's that sort of transparency edge. But transitioning then into your question about disclosure and sufficiency, this is an area where I tend to be pretty conservative in my advice about disclosure, because I think it saves you so much when you can do an adequate and appropriate disclosure. It's going to save you from the perpetual, government watchdogs that might be out there just to try to get an I gotcha moment and file a complaint. Because, did you have, oh, sure. That's okay. Oh, please, yeah. Sure. Please, yes. Yeah. Yeah, that'd be great. That'd be great. But what I was suggesting is just disclosure is really your opportunity to sort of stop the effort that might be afoot to sort of have those I gotcha moments. And so what the Ethics Commission opinions say is that, and the statute actually says that the disclosure has to be sufficient to inform the public of the full nature and extent of the conflict. And the reason why I'm a little bit conservative when we talk about disclosures is because 9 times out of 10, the more you explain about the circumstance, you're going to be probably talking yourself out of an abstention, because you're going to be probably explaining the remoteness or the fact that the issue you're being asked to vote on is not going to directly or materially affect those interests in that way, and you're going to be able to talk yourself out of the abstention. And so that's the benefit in my mind of disclosure. Now, it can be sometimes uncomfortable, as we know, in public officers serving on public bodies, to sometimes disclose things of that nature. Attorneys primarily also have a different component, because sometimes there are attorney-client confidentialities and things like that that make it even more difficult to disclose those issues, because you're governed by an entirely set of professional rules and responsibilities. And so, again, that's why I caution disclosure is so important, because it's particularly in some smaller communities, right, where everybody tends to know everybody, and I don't say that casually, I mean that sincerely, which is that in communities that are close-knit and more of our rural communities in eastern Nevada, we see this all the time. And so sufficient disclosure to inform the public. That's not just our public officers, that's also our public employees. And so we find situations where our public employees are being asked to make some relatively significant decisions. Sometimes they come as far as the city council, and sometimes they're just, I mean, in my capacity all the time, I'm making tons of decisions that never make it to the commission level, whether it's, you know, reviewing resumes or whatever it might be doing. And if I'm doing that in the midst of a conflict and not disclosing that to the commission, then I could find myself in a world of hurt. And so that's sort of the backdrop of disclosure, sufficient to inform the public. Now, when you talk about how far the duty goes to know what your conflicts are, there have been situations where the commission has come down and essentially said, it's unreasonable for you not to know certain types of conflicts, right? So if it's an issue under consideration by you in your public capacity that has the potential to affect your spouse's interests or your business affiliate's interests or something like that, then they're not just going to accept I didn't know. They're going to impose this sort of duty to know type of thing. And so again, there's a reasonableness standard there. And I don't know how, because the types of issues that you're confronted with are so diverse, it's hard to know without a specific example whether you have, a duty to know whether one of your interests may or may not be affected. But
well, I can give you a specific example.
Okay. Great.
So in my, in this particular ethics investigation, it was kind of a surprise. It was one of those situations where Mayor Toller was still mayor at the time. He, in Urban Jungle, was the contractor. He disclosed when we got to this consent agenda item that Urban Jungle had an account at his hardware store, I believe was what happened. Well, that's when I realized, hey, Urban Jungle's one of my clients. And so off the cuff, I said, I represent Urban Jungle. This is like 4 seconds later. I represent Urban Jungle on an unrelated matter. City attorney, is that sufficient? Do I have to abstain? And his opinion was no, not if it's an unrelated matter. I didn't. I mean, I could have disclosed more about Urban Jungle, especially if I hadn't been surprised by it.
Sure.
But I think the crux of the issue was that it was an unrelated matter. I mean, I'm not sure how much I could have disclosed because of the attorney-client privilege.
Sure.
And then, so fast forward to the end of my ethics investigation, and Dan Stewart, who sits on the Ethics Commission, no longer, but did at the time when we were just approving the stipulated agreement. He discloses there that he's going to abstain because he's related to me somehow. He doesn't know how. So I'm thinking, okay, wait a minute. And of course, I'm biting my tongue. I'm not going to speak up, and nor would I want to. I mean, I don't think that's problematic for him to do that. It's not. I don't want him to be penalized for that. I don't think he should be. I think it sends the wrong message to the public when it's this kind of a gotcha thing. But it's a similar situation where he just said, I'm related somehow. I said, well, I'm unrelated somehow to Urban Jungle. I'm pretty sure you guys aren't investigating him, but we get hit with a separate non-willful, albeit separate violation for non-disclosure, or for failing to sufficiently disclose, just because I didn't say more about Urban Jungle. So it seems like a little bit of an ironic twist there, and so I don't know how we reconcile that.
Well, and I agree. Certainly that disclosure could have been fuller. In that instance, so twofold. Number one, I think it was clear from Dan Stewart's perspective, I'm related to this individual. I can't be objective, therefore I'm abstaining. So it ran the gamut, right? It was not just a disclosure and then he ended up voting anyway. It was, I'm related to this person, I'm out. And so he could have been clearer. He could have said, I'm related to this person in this way, and therefore the ethics law says that I have a commitment in a private capacity to him because of this familial relationship, and therefore I'm going to abstain from voting. He could have said that. In your instance, what I think would have been helpful for you in that instance would have been to go through that analysis, sometimes out loud, but even to just let the public know, because it might have even triggered for you oh, well, it's the relationship that I have with this client and not necessarily the matter that's under consideration because I'm not affiliated with that matter. I represent him in a different instance, but it's the relationship that triggers the conflict. And it could have been if, had you been able to say, and perhaps even know that that's the extent to which the ethics law applied in that way, which is to say, actually, now that I'm sitting here, I notice that Urban Jungle is one of my clients, and because I have that attorney-client relationship with this individual, I probably should abstain from voting because his interests, albeit unrelated to mine, are being affected by this matter. And because of I always replace the spouse with these issues because it becomes more obvious, right? Like if that had been your spouse and Mayor Tobler had said, oh, Mayor Woodbury's spouse is before, so I'm going to disclose, you would have been like, oh, that's my spouse. I probably should stay out of this in its entirety too because of that relationship. And so that might have helped sort of, kind of going down the chain of the full analysis to say in the disclosure to say, oh, okay, well then maybe because their interests are being affected by this matter, I should stay out of this issue. That could have helped. And I understand the irony you're talking about, but.
Right. And I appreciate your connecting it to the abstention part, and I understand that. But I'm trying to focus primarily just on the disclosure part of it and the duty to go investigate part. And maybe what you say is true, that I would have come to the conclusion that I needed to abstain, and this was an education process for me, but going through the process, they were treated separately, so they were separate violations. Just the failure to abstain was one, but the failure to sufficiently disclose in each instance was a separate alleged violation, and it's treated as such. And so whether or not you abstain doesn't really affect whether you fully disclosed. And so did Dan Stewart, for instance, have a duty to investigate more fully his relationship to me in advance so that he could more fully disclose that?
It's possible. At the same time, the public may have also said in that instance, the public was sufficiently informed that he had a familial relationship with this individual. Maybe. Now, does the commission require that the full nature and extent of the disclosure be the exact type of relationship and, it could be, possibly.
But couldn't you say the same thing about the attorney-client relationship? Isn't it sufficient to disclose that that exists and that it's an unrelated matter?
Possibly.
Okay.
I mean, yeah, it's possible.
All right. So as much as possible, I hear who, what, where, when, why.
Let me be fair. So I think when we look at the issue of disclosure and abstention, if you can at all put yourself in the position of a member of the public who's trying to understand, may not have the same level of insight and perspective and sophistication that we do as members of the City Council about the issues that we're being asked to vote on. And so if you can put yourself in the shoes of a member of the public who might just be sitting and happening to listen to a City Council meeting, and all of a sudden someone says, oh, well, that's my client. I'm just disclosing that's my client, but I'm going to go ahead and vote anyway. That member of the public is probably without the insight thinking, well, wait a minute, how can that be somebody's client and yet they're still voting on this issue? And so sometimes they're hand-in-hand issues. And if we can look at the sufficiency of the disclosure to sufficiently inform the public of the nature of the conflict, that's kind of where sometimes the commission is looking at those issues. Now, I think where it can be read in conjunction with abstention would have been a situation in which had Dan Stewart disclosed this is a family member of mine and gone ahead and voted, then the public's left with, again, the same situation. Well, wait a minute. He just said he was related to this individual, and yet he's voting. And so am I sufficiently informed as to why it's appropriate for him to continue voting on that type of issue? And so it's rare that we see a situation where an insufficient disclosure is a standalone violation, because usually it's read in conjunction with, in the circumstances, not by the law, but in the circumstances with an abstention. And so sometimes we have to figure out if the disclosure is sufficient to inform the public of what's going on based on the agenda item. And so it is fact dependent. It's not just if, who, when, or what, but it is dependent on the facts and circumstances of every case.
Okay, well, I appreciate that. You've articulated at least one perspective on it. And, you know, it's a little frustrating for me to go through the process and to have the whole first part of the process till the very end in the investigation for me was about non-disclosure. Non-disclosure, in fact, the first draft of the stipulated settlement agreement that was presented to me, which was just all about failure to sufficiently disclose. And so that's why it highlighted to me the fact that all those are treated separately. And then it came back on, after I had made changes, it came back that we were going to put in and tie that to, not tie it to, but to add the non-abstention as well. So
I can certainly talk to you about that individually, but I think, you know, in that instance, when drafts were going back and forth, when I got a final edit, my view of it was, wait a minute, we have to look at this in the totality of the circumstances, and that's, you know, in the drafting process, that's, I think, how that occurred there, which was just an acknowledgement of what are we really talking about here, and this is the issue of concern as far as public policy goes. But
all right. Well, I'm just looking for certainty as much as possible for everybody, so that we all know what our duties are.
And I appreciate your point of view, and I think above all, the Commission really does respect very much the position that public employees and public officers put themselves in. Despite some of the decisions that come out from the Commission that might, you know, appear to the contrary, there really is a very sensitivity to and a respect for those of us who are serving the public in these ways and putting ourselves out there and having these challenges confront us. And so I think there's always been an effort afoot from the Commission to sort of become more sophisticated in our ability to deal with these types of circumstances. Not only for those of us serving in the position, but also is it an appropriate use of state resources to, you know, expend our time looking at these issues when it really should be, you know, focused on, number one, education and outreach, and number two, bad faith types of conduct that are going out on in the state. Go ahead.
Let's say, for instance, you had a city council member who was also a real estate broker and had some real estate agents working for them, and then they were voting all the time on housing developments, and might potentially, the agents would sell those housing developments in the future, some of them. How much disclosure you think should be made in that situation? So
this is actually a really great question, because the Commission has had occasion to issue a couple of recent decisions that affect real estate brokers and real estate agents who also serve in public bodies with regard to disclosure and abstention. And the Commission has actually been, again, pretty clear that disclosure and abstention are going to be required in circumstances where you're voting on something that affects your brokerage, an agent, a property that's listed within your brokerage or by one of your agents or something like that. So that's pretty clear. But I think what the question you're asking is this idea of potential business. And that's really kind of an interesting area, because the law doesn't say you have a duty to disclose potential conflicts, right? And so I think what gets important about that issue is that it's not so much a disclosure and abstention that might be triggered in a situation like that, where I could see, and again, not implying that that's the circumstance here, but what the Commission would be concerned about down the road would be a situation in which you were using your position to vote things in to ultimately benefit your private business. And so because you have the authority and the access and the power as a city council person to vote something in, you know, whether it's a zoning variance or a master plan change or something like that, that ends up having the benefit to affect your business in that way, have you misused your position to provide?
How do you avoid that?
Well, so one of the very important distinctions here is, number one, is it unwarranted? And number two, is it affecting your potential business more or less than anybody else who would be reasonably affected by it? So if every real estate broker in the community is going to have the same chance because of this zoning variance and it doesn't affect your business anymore or any less, then you're fine. It's probably not unwarranted. But if you already own the land and you already have the plot going and the decisions, you know, setting up, and you just need to, you know, get this decision made on the city council, and you're wielding your authority and doing all that and then ultimately voting on it, It's not so much that you had an actual, well, in that instance, if you already own the property, you probably had the conflict and would have needed to abstain. But in those instances, we're worried about other statutes in which we can later prove that you sort of somehow misused your position to give yourself an advantage over the members of the public. And so in those instances, that's where I would be more concerned rather than disclosure and abstention, unless it already existed for you. I'd be more concerned about facts that support that. Now, if you just happen to be a business person who will benefit from a decision the city council ultimately made, then, you know, that would be the same as if the city council voted in a tax rate increase or, you know, that affected everybody across the board, or, you know, for example, members of a school board who might vote in a benefit to students and their kids happen to be students within the school district or something like that, that has the same effect overall for everybody, then we're not going to find that that's an unwarranted use of your position or an abuse of your position in that way.
Hi, I have kind of a different situation. I wasn't raised in Nevada, and I don't have a big extended family, but I married a man who was raised in Nevada and has a huge family. So through marriage, I'm related to a lot of people. And mainly with respect to an auditing firm, a big auditing firm in Las Vegas that audits many municipalities. He has a cousin and a nephew who work for that auditing firm. I always disclose that through marriage I have a nephew and a cousin. But I think it has, I guess I need to do that, but I think in some ways that has hurt them, because then these, as Rodney said earlier, these predators catch that, and then they implicate that I have had some kind of influence in hiring that auditing firm, because it's not just here in Boulder City, but it's on another committee that I serve on as well, that they use the same auditing firm. And of course, I have nothing to do with the negotiations. I don't benefit in any way whatsoever, except that there is this relation through marriage. So I feel like in some ways through disclosure that I've brought some kind of, I don't know, black cloud over them because they're related to me through marriage.
Sure. Well, you're correct that the relationship through marriage is certainly required to be disclosed. I mean, that's, you know, it's the same relationship through affinity rather than consanguinity, right, in that instance, through marriage as opposed to through direct blood relationship. And so in that instance, you're doing the right thing by disclosing those relationships because that is a conflict of interest under the law. Now, I mean, sometimes the family members and the businesses suffer for those of us who are in public service, because there is, you know, including even, you know, more directly, we've seen circumstances where perhaps what if your husband was, for example, owned a construction company that bid public works projects for the city of Boulder, or Boulder City. And so, you know, these kinds of things are problematic from a contracting point of view, right? And so, funny I should mention that. Do we have...
my husband did years ago, but that was long before I was on council.
Sure. But we do actually see those types of issues, and that triggers, you know, contracting provisions and having financial interest in contracts with the very city that you know, are a member of the governing body and things like that. But so, you know, I don't really have an answer because, you know, unfortunately, sometimes that's just the reality of it. What you have as a duty as a public officer is transparency to the public, an opportunity for the public to know what your personal interests are when you're making decisions on their behalf as a member of the public. And so, you know, yes, there's this component of what the Ethics Commission is responsible for doing. And then the flip side of that is that, you know, then the public, they have the whole democratic process. If they don't like the fact that you have these conflicts, they won't vote you back into office, these sort of inherent conflicts, right? And so, you know, if you're disclosing and doing what you should be doing and avoiding those conflicts appropriately under the ethics law, and you nevertheless have these conflicts and you feel like, you know, if sometimes people have so many conflicts that they're precluded from voting on anything, and then they're just not productive public officer. And so that might be then the public's jumping in and saying, you can't vote on anything because you have too many conflicts, so maybe you're not our best representative voice in government. And that's when that becomes an issue.
So given the relative thing, do I have to disclose that my daughter's husband's dad is an attorney for some of those people? Is that too close? Our children married each other. They were high school sweethearts.
Okay.
Wasn't planned by us growing up. We didn't.
Yeah.
So,
Well,
I never have, didn't think of it, but are you telling me now that I have to be concerned because 3 steps away is Rod because of our children and he represents somebody,
well, I
so
would,
I've got to stop and go, wait a second.
yeah.
I need your 200 list of clients.
Well, you know, again, so in this instance, your daughter's spouse is a relationship within the 3rd degree of affinity for you, right?
Yeah.
And so if your daughter's spouse is affected by his clients and those clients are before you and that affects the interests of your son-in-law, then potentially yes. Now, depending on how your son-in-law's interests are affected and if they're material based on the issue that's before you, you very well could have an abstention.
He's raised a good
obligation.
boy. He doesn't give him much, so.
But there is definitely a possibility of that. And that's when you get into the sort of materiality of how are the interests of your son-in-law affected by the matter that's before you.
Okay. So my question's a little different, and it ties to what the mayor was saying, and I think he raises a good point. So we do our best. He's done additional steps we've taken as a council. In my case, talked with council, talked out loud, decided that I would vote on a matter, and a member of staff filed the ethics complaint. So why is that not a responsibility of that staff member to not have done that at the time and disclosed or said, this is a concern to me, but now throws it into the process when they were here and had that chance? I don't believe that's the public, like you've kept mentioning. The public is a different characterization of the community at large. In the case of what the mayor was saying, or Councilman McCoy was saying, the mayor's issue was from another council person, not the public, as you're calling it. So the question just is, when does that taken into account by your investigation, let alone going to the commission in that? Because my willful, and I think the mayor's, we didn't go before him. And I still feel like I really didn't do anything wrong. And it's evidenced by the history of it, but it was a staff member, not the public.
I am not entirely sure that the commission views public in the same way that you are. And so, in some respects, the commission, unless it becomes a credibility issue, is not going to be concerned about who is bringing the complaint or their motives for bringing the complaint. Because it could be the absolute worst bad faith reason in the world to bring a complaint forward. If someone's violating the ethics law, you know, whether they're just doing it to be a nasty person doesn't really reflect whether or not the person violated the law or didn't. And so where credibility becomes an issue is, so if that person's the only witness to this alleged conduct and they're, you know, a bad faith person and they have a history of lying and we can't rely on that testimony as truth or accuracy for what's happened, then we might be worried about the motivation of a person to bring a complaint. But ultimately, the commission stays out of motivation as a basis for bringing a complaint altogether. And I don't think we view, you know, a staff member as not a member of the public bringing a complaint forward, because the same reason I told you, most people that have information about ethics violations are the very people who are working in the agencies because they have knowledge of what's going on. Usually members of the public.
So they have no obligation to, in the public process, in the room, when disclosures are made, make any representation or concern. They just step back, even though they have an obligation to the city and to the community at large. They don't have any repercussions. So the comment the mayor said is, even though he's doing that, they could bury something on page 400. And they're not the clerk that did it. They're the public works director. And now he's going to get a violation. Now we know, Scott. It was Jim. It wasn't Scott, right? Oh, but so you see what I'm saying? Isn't there a responsibility of that policy preparer to then turn around and file the ethics complaint?
So I think that if there was evidence that one of the staff members intentionally was burying something to sort of have a catch-you moment, that would be evidence in support of the person who we're investigating as to why they wouldn't have been informed of a situation or why they might not have known there was a conflict or something like that. So again, we don't have the authority to go after the sort of bad faith reasons why people file complaints, because that's that First Amendment unconstitutional area that we were told we can't go near. But imagine the flip side of that argument, which is that, in terms of, we can't put our duty to have our conflicts on somebody else. Our duty to make someone else inform us of our conflicts or our issues. We cannot put that responsibility on someone else, even a staff member. And so just because there's a discussion afoot, but for example, by members of the city council and potential conflicts, I could imagine there would be a situation where a member of the staff would feel uncomfortable saying something or feeling like it wasn't their place to say something. I mean, that's why we can't, necessarily impute that into our staff members. If we have the conflict, it's our responsibility to do that. Now, if they're hiding something from us.
Well, I don't disagree, but then when that employee is let go and then goes back a year and finds stuff, which is the case, it wasn't taken into account.
Well, I think if those facts exist, it would be taken into account by the commission in evaluating whether or not the person who is alleged to have violated the law did so intentionally, what the circumstances were surrounding whether or not they disclosed it. I think that would be...
has to go to the commission to do that, because I never got to the commission. My violation only went to yourself probably 8 years ago, 10 years ago, or 6 years ago. And the investigator who did the same thing as the mayor, this is ridiculous. I mean, and we didn't have the minutes. We didn't have recordings. It was fully disclosed and discussed. I followed the advice of counsel, and it was a disgruntled employee who had left. And luckily, just before the statute of limitations, it was snuck in. And it's like, okay. Well, and now, like the mayor's saying, the fact that there's a violation, forget the willful or non-willful.
Right.
I mean, it was in social media, the mayor's from a year ago, yesterday. So while you don't think it's non-willful, it's no big deal. You've really impugned in the public's eye an individual of character and standing in our community, and so that's the concern. And I think it's great you're going to the legislature. You do it every 2 years. So, what's the difference now? And we can't rely and hope that it's going to change. Well, and I'm wondering what discretion you have, because in my mind, Boulder City's picked on more than other communities, because you don't hear about this in other communities. And I think it's evidenced by the fact that you're investigating the things that are going on here. And if you got 80 of them, is that how many you get in a year?
90 to 100, approximately.
And how many? You investigate 20?
About that, yeah. Sometimes more, sometimes less.
How many willful violations, non-willful, did you give last year?
I guess I don't have that statistic handy. But, out of probably maybe the 20 cases we would have investigated in fiscal year 15, it would have been on the low end that there would have been willful violations out of that group. So maybe 2 or 3, and the rest would have been non-willful, unless they were dismissed outright at the panel, which happens, quite honestly. A lot of times there's a recommendation that allegations be dismissed in their entirety because the evidence didn't support it, or something of that nature. And so I mean, I absolutely respect what you're saying and the concern that Boulder City seems to be singled out a little bit here. And number one, that's simply because you have some vocal members of the public who want to bring these issues forward. It's not to say that, we're singling out Boulder City. Certainly, we're responsive to the public complaints that are coming in.
I think I'd say public is different than city public officials. When you look at it from the director level and the council level. So
I don't know that commission sees that distinction in terms of, any person who's bringing a complaint forward from the commission's perspective is deemed to be a member of the public.
So just to piggyback on that question, I want to talk about these stipulated agreements that are also, I think, titled an opinion of the Ethics Commission.
They are.
As I was going through my process, it was brought up several times through the investigators, and I heard back through my attorney that, we had these stipulated agreements in Councilman Walker's case and Mayor Tobler's case, and even in the interview I had, the investigators said directly, and I also heard this back from the attorneys, or from my attorney, that the Ethics Commission, which I assume meant you, and your name was actually brought up, feels like Boulder City really hasn't learned its lesson. And, you should have known because of these prior stipulated agreements. So my question, I guess, is two-part. One is, what do you view those as? Do you view those as precedent? And, because, honestly, I had never read those, but it seemed like the message I was getting is I should have read them. Ignorance is no defense. You should go read those. And then the second thing is, that troubled me a lot that I was hearing that back through my attorney and directly from the investigators that Boulder City hadn't learned its lesson on that. So obviously I don't want to impute to you something that you didn't say, but that is the message I was getting back. So you have the chance to respond to that.
Well, thank you for the opportunity to respond. I have never said that, clearly. I think what I have said is that there would be a great opportunity for us to come and educate Boulder City because that we're seeing these types of complaints coming through, and maybe there needs to be some clarity about the types of conflicts that the commission's looking at. But certainly never did that come from the commission nor myself directly that, Boulder City hasn't learned its lesson. That type of language would never come out of our office, certainly not the commission, and they're subject to open meeting law, so that's never been something that's ever been, articulated by the commission to my knowledge. And so I certainly apologize if that's a message that's been received by your jurisdiction, because that's not something that the commission feels or that I feel at all. I think what I am concerned about is that we continually do see complaints out of Boulder City, and it was my hope that we could come out here directly to have this type of conversation for this very reason. All of the questions that have come up today, all of the types of conflicts that we're seeing, and those types of issues, because I think, one of the greatest things that we rely on are our partnerships with NACO and Nevada League of Cities and those entities that are coming out and doing ethics training. But what I think that they're doing is they're giving kind of an overview and not being able to get into the nitty-gritty and knowing the history of the opinions and the decisions that the commission's issued. And I think that's one of the benefits that I can offer is kind of, these are the types of things the commission's concerned about. This is the direction of their opinions and where they've gone. And so I certainly apologize to the city if that's the impression of the Ethics Commission, that we have some sort of view about Boulder City. We certainly do not. And we do absolutely understand and appreciate that the nature of the types of complaints that we're receiving are certainly nominal, and not these true bad faith, malicious intent to get away with anything at all. We've never had that impression of or concern about Boulder City in my entire tenure with this commission. So I think obviously the circumstances with former Mayor Tobler left some bad taste for the city, and I think that I was happy to see that legislation that came out of that circumstance with the mayor, and I think that that was always a positive thing. So if I can say sincerely, I apologize if that's been the impression of Boulder City. And my whole intent is to be cooperative with your agency to prevent these types of complaints coming forward, to work with you folks, get your insight and your input on the issues that we as a commission are bringing forward. Because I'll have to tell you, the commission's in a unique situation when it comes to legislation in that, we are not the policymakers for the state. That's the legislature. The legislature is directing us what statutes to enforce and interpret. And so we have the benefit of giving our experience to the legislature in proposing these legislative measures, and telling them what we think would be good policy for the state, but ultimately we don't get to be those decision makers. And so that's sort of where our efforts with our legislation come in, is really to sort of give some input to the legislature about this is what we think is good policy going forward based on our experiences. So at the outset, I sincerely apologize if that's been the impression from the members of the city council or members of your staff that we are having some bad intent or bad feeling about Boulder City. And certainly I'll share that with my staff if they're making those types of comments. That's really inappropriate, and I apologize for that.
Can you speak to the precedential
Yes,
effect
absolutely.
too? Because, back in the 90s, there would have been a few dozen
Sure.
official opinions out there, but now with this proliferation of these stipulated agreements, you add that in plus the full-blown opinions, you've got hundreds of them, and so the whole ignorance of the law thing, can we really be expected to know what the nuances are and all
Yeah,
that?
a couple of things. So when the law was changed to add those mitigating factors into the determination of willfulness, at that same point in time, and I think it was 2013, the legislature also added this language into our statutes that indicated that stipulated agreements would have the same precedential value as commission opinions. They would serve as an opinion. They would be deemed to be precedential in terms of the types of conduct going forward. And so that's why you'll see sometimes not the most simple stipulated agreement, which is public officer agreed to non-willful violation, period, move on. It's that we're trying to put some information in these stipulated agreements to provide that sort of education and guidance going forward for people who might be similarly situated because that statute came into the law. And the other reason why you might be seeing more stipulated agreements than we ever saw before 2013 is because in 2013, we added this associate counsel position to our staff. And what we were seeing before that time, when I was serving as commission counsel, we were seeing this, in my view, crazy circumstance where every case that was coming forward was putting commission counsel in this sort of due process conflict, right? Because in one instance, I was preparing a case for hearing, and in the next instance, I was advising the commission about what all of this stuff meant. And so the legislature agreed that's an inappropriate position to have because I can't independently cause information to come forward for a hearing, witness testimony and exhibits and all of those kinds of things, and then secondarily be advising the commission about what all that means. And so we brought in this additional position to make these very clear lines that commission counsel would be solely responsible for advising the commission, separate and distinct from anything having to do with a third-party case and the investigation and bringing evidence forward to the commission and to the investigatory panels. And so whether by happenstance or intent, I'm not quite sure what happened, but as of getting that position in the commission, we saw nearly every case result in a stipulated agreement versus going down the road of hearing, and it was a complete overhaul. It was almost every case went to a full-blown hearing prior to that time. Well, not every case, but a lot of them. And then now we've seen a situation where most people are, don't really see the value in going forward to a hearing and calling witnesses and those types of things, where we can resolve it through a more simple stipulated agreement through these findings. And I think you'll find certainly more non-willful violations since 2013 than ever before, because that sort of strict liability standard changed. And also because we were able to negotiate with these subjects that were coming before us. Look, this really doesn't warrant a need for an evidentiary hearing before the commission unless there's a dispute about the facts that are going on. So I think that's the history of why we've seen that change, but we are certainly responsible to review and depend on and cite to former stipulated agreements as opinions of the commission. when we go forward and looking at new things. A couple of other things. We just launched a new website. It has all the same information that our old one did. But the safe harbor provision that's in the law, again, only confronting the willful violation issue, that was also amended in 2015 to indicate that, it used to be this sort of, I don't want to say loosey-goosey, but it was this looser approach to safe harbor, which basically said if you relied on the advice of counsel, if your conduct didn't violate a prior published opinion of the commission, and you acted in good faith, it was protection from a non-willful. And in 2015, the legislature amended that language to make sure that it was the lawyer who was responsible for not giving advice contrary to a published opinion, because it was absurd to think that a public officer would be in a situation to know whether his or her conduct would violate a prior published opinion of the commission. And so now we've put that onus on the public attorneys, because presumably they have access to our body of law to determine whether or not they're advising something that is or is not contrary to a prior decision. And that's the whole hope going forward. Again, that still is only applicable to the willfulness standard, but they are precedential stipulated agreements. What's that?
That's only on the willful violation.
That is, yes. Except that for the safe harbor protection, that's true. Nevertheless, all stipulated agreements before the commission are treated as formal opinions, and they, under statute, serve as precedent.
So and I just want to express my opinion on this because I think it's important as you go into legislative session to know this, but I have a problem with those serving as precedential value. I think it's a good thing that you're trying to encourage settlement, and avoid the cost and expense of going to a full-blown hearing. But there's a lot of reasons why somebody that's had a complaint filed against them might agree to a stipulated agreement, many and maybe most of which have nothing to do whether they actually agree with what you're saying in there. And yet then you're elevating that to the status of precedential value as though this person somehow agreed to it. I mean, you settle on those things because it's costly, it's time consuming, it's emotionally draining. It takes away from the focus of what you're supposed to be doing as a public official. By the way, some of us have other jobs that we're supposed to be doing and where we actually make money and those types of things. And so to take what I call a settlement agreement, which it really is, I mean, it takes two to reach that.
Sure.
And then to elevate that to the status of precedent going forward, I think is a little bit deceptive, as well as I think it gives more credence to what actually happened in that process than did. And I understand that, part of that's just the Ethics Commission wanting to get information out, but then taking it to the precedential level, I think is problematic.
I think that's good feedback for the legislature, and it's certainly something I don't mind sharing with them, as far as is concerned from, public officers who are subject to that. Again, the only counter to that I really would have any comment about is really just that the public policy intended to be promoted through that particular statute, I assume, because it came in at the same time that these mitigating factors came in, was really just about transparency to the members of the public, which is, this is the final resolution of the case. This is the public policy behind the commission on behalf of the public reaching this decision. And it's a manner of, informing public officers who are similarly situated that this is how in other words, it's holding the commission accountable that when we see a similar set of circumstances by the next public officer, we're not going to settle that one for $5,000 when we gave this guy $1,000 for basically the same conduct. It's some accountability and transparency is, I think, what the goal of that particular statute was. But I appreciate your feedback about that. Any other questions? Yeah? No? Okay. All right, well, yeah, go ahead.
Just one broad, you're probably going to dismiss this, but open meeting law, you said earlier that you don't really have anything to do with that. I do have some questions about that, but it sounds like you don't want to answer those.
Yeah, we don't have jurisdiction over open meeting law issues, and so it would probably be inappropriate for me to advise you about application of open meeting law issues. But if there's a relationship of an open meeting law issue to ethics, I'd be happy to kind of confront that issue for you.
Okay.
One thing I will share with you that does have a lot of interaction with ethics and government law, and you know, we certainly don't see these issues that affect the members of city councils as directly as affects the staff members. But one of the issues that we see quite a bit is this statute that prohibits public officers and public employees from utilizing government resources for private purposes. And this has some interplay with public records, for example, and primarily because of use of the internet and use of government email and those kinds of things. And so you guys have all probably been subject to the public records request for every email you ever sent between January and you know, March of whatever year involving XYZ. And so sometimes, you know, when your IT staff has to turn something like that over, it might also show that you know, sent 30 emails, you know, about you're shopping to buy an auction car or something like that, and you're doing that from your government computer. And so sometimes there's interplay, right? Because it might not have cost the community or the jurisdiction or the city any more money for you to send those emails from your government computer, because the cost of internet is the same across the board, whether you use it for an hour or whether you use it for 5 hours. Those types of things. But staff time is certainly something that is accountable to the taxpayers. And so when our public employees are searching the internet and spending all their time, you know, on email and those kinds of things, that does trigger ethics violations. And then it also, in a public records context, can trigger some embarrassing circumstances, if you will, if you're turning over records that show, you know, someone hasn't been faithfully discharging their public time for public reasons. And so sometimes there's interplay and things like that. And with open meeting law, where we do see some interplay with the ethics and government law, might have to do with, you know, suppression of documents if there's some allegation that the public's not being provided the same information that the council members are, along with the agenda, or things like that that can come up that we can have some interplay about, but it's pretty rare that we see those types of issues. And usually if it's pure open meeting law, we'll refer those issues out. So, well, I didn't get a tarot. I don't want to keep you guys forever. I already have. I do have, you know, in your packets there's sort of an outline of the other statutes that come up a lot. I'll just touch up on a couple of issues that might be relevant to you in your various capacities. One of them happens to involve gifts, and that's an issue that the Commission's seeing quite a lot lately. And it's this question about, you know, what is or is not an appropriate gift to accept in my official capacity. And so the statute does not define gifts, and it doesn't define gifts specifically because it would be impossible to know the type of gift that would improperly influence a reasonable person in your situation for every type of thing that could be potentially offered. Where we see it the most questionable are situations in which members of city councils might be offered tickets to attend an event or an opportunity to go to a city, you know, business opportunity or something like that. And typically what I'll say about that is that, you know, you really, when you're being offered something, whether it's tickets to an event, or whether it's, you know, an opportunity to go play golf and conduct business on the golf course, whatever it might be, the question you should probably ask yourself is, why is that person offering it to you? Is it a gesture? Is there some potential that that person's going to be before you in the next week or the next month or the next year for something that you might be able to do for that person in your official capacity? And it's really sometimes about thinking about why the gift is being offered in the first place. If it's that you have coffee with this person every week and you buy one week and they buy the next week, there's really not this opportunity for improper influence. And that's sort of the triggering word there. But the Commission recently did just issue an opinion, and it happened to involve a state employee. And I bring this up because I thought it was a pretty significant case, and it involved a $10 lunch. And this public employee had accepted payment of a $10 lunch from a vendor during an existing RFP on multi-million-dollar contracts with that state agency. And so, albeit completely nominal in terms of the amount of the gift, it was the perception, right, that this vendor was getting an advantage because they were paying for lunches with this particular public employee. And so the commission came down pretty hard on that issue. And so I just wanted to kind of draw those issues to your attention, that even accepting a lunch in the wrong circumstance could trigger, perceptions that it's improper influence.
Yeah, thank you for bringing that up, because as a matter of fact, in one of the social media groups involving a group called Boulder City Community Alliance, it has been suggested in the last couple of days that we have a local developer who is giving gifts to city councilmen. Mm-hmm. And I don't know if you picked up on that from some other source in the last couple of days, mm-hmm. but I'm not personally aware that that's actually happening. This is something that's being suggested right now, though.
I have not heard of that. I haven't
regards
watched.
To sports tickets and fancy meals out on the strip and things like that.
Now, what I will say is that there are a lot of circumstances in which. What's up? Yeah. Yeah.
It's an allegation that's floating around right now. We have had people come to our city council meetings and accuse us of being on the take on a fairly regular basis in the last several months.
Okay.
There's all kinds of stuff floating around right now, and
that hasn't.
I'm tired of that.
And that's fair. That's not something that's come to my attention, and certainly just because someone said, I saw him at dinner with so and so, he's obviously got to be, getting a kickback or something like that, I would say, well, that's great that you say that, unless and until you have some proof to support that allegation, I'm not just going to take a broad-based, certainly nothing on social media, but in and of itself. But what I will say, though, and which is wholly appropriate for members of city council and even certain staff members, if there's a governmental purpose for you to attend an event or, a conference, or is Boulder City sponsoring economic development in the form of a baseball team, and you need to go see what the baseball team is doing for the, those types of things are wholly appropriate for our representatives in government to be doing. So if you can tie it directly to an appropriate government purpose, then that's not an unwarranted gift that's intended to influence you to act inappropriately. And so those are the types of caveats that, we'll see to gifts. But if there was a situation where there was a genuine kickback going on and someone was, paying for your meals and all of these things for you to be able to vote on something, that would be concerning.
Well, this is probably not the first or the last time that phony allegations are going to be made. But within the present political and social climate that we have, there seems to be an impression that if something is said often enough, it becomes true in other people's minds, and that's a danger.
I agree. Well, I would hope to say, rest assured, the commission hears lots of things in the media and otherwise, and, we're prohibited from relying solely on any kind of newspaper or social media article to prompt any action on our part for those very reasons. Those are genuinely, in and of themselves, unreliable resources if that's all that we're provided. So, I'm not terribly concerned about anything I see in social media as a course, or the media for that matter, as a course of prompting commission action in any way. Yeah.
That brings up a question in my mind. I thought that you could only act on an ethics complaint if it is brought to your attention. So if you do see something in the paper, you can act on that?
No, in fact, it's the opposite of that. So we have two available avenues to pursue a complaint. One is if a member of the public brings it forward. We also have the statutory authority to initiate a complaint on our own motion. We cannot rely solely on media or a newspaper article to prompt us to initiate a complaint on our own motion. That is a prohibition against that authority.
But you do have the authority to bring...
We do.
Because speaking of that same council person years ago, so we had a sitting councilwoman who represented a group who was suing the city and that was not considered an ethics violation?
Well, possibly.
I mean, this wasn't, as far as I know, wasn't brought to the Ethics Commission by any individual because everybody was afraid to take her on.
Sure.
But to me, that seems like a clear ethics violation if she is a sitting city councilwoman and she's acting as the representative for a group who's suing the city.
So certainly in an instance like that, there could have been the potential for the commission to initiate a complaint had it had information to support a complaint going forward. Now, what I will tell you about that is, although we have the statutory authority, in practice, the commission is not in the business of going into every jurisdiction in the state of Nevada and seeing who's doing what and filing complaints against these individuals. So typically what will happen is that and in fact, the only times I've ever seen the commission utilize this authority is if and when it learns about conduct of public officers during the course and scope of other related business of the commission. So we're not just perusing, what's going on in all of the various jurisdictions. We're not the sort of ethics police out there, law enforcement coming out and trying to find who's doing what in every jurisdiction. We almost wholeheartedly rely on members of the public to bring these issues to our attention when we're processing a matter in a complaint fashion. Where I've seen complaints initiated on the commission's own motion, for example, might be a situation in which we're investigating a complaint, and during the course and scope of that investigation, we learn that public officers X, Y, and Z are also doing the same thing. Or we learn of conduct that has occurred by virtue of investigating another matter or processing something else. Then we have, in that instance, filed complaints on our own motion to investigate and look at what's going on with those individuals. But that, to me, is not a circumstance that I'm aware came to our attention by a member of the public or that we would have been aware of.
It's right there in the statute.
Well, it could have been. Yeah, it very well could have been. I think that so from my perspective, the commission was never aware of that to prompt them to decide whether or not they wanted to pursue that on their own motion, nor did a member of the public bring that to our attention. So likely those types of circumstances could be happening all over the state, and we are in some instances reactive to the types of complaints that are being brought forward. It's not unlike most agencies who are just responsive to complaints that are filed, but there was not a complaint to my knowledge that was filed. There should have been. Yeah, but I welcome you to bring those complaints forward if those types of issues are going forward. And to that note, in 2015, if there is a concern, people who work in the same agency being concerned about bringing those issues forward, there is some protection in the law now to allow those individuals to remain anonymous if they work within the same agency against the person, about the person against whom they're bringing that complaint. So that was one effort at tackling sort of that fear of people coming forward, because we have to, as a commission, rely on members of the public to bring these issues to our attention. And what we find most often is that there's an unwillingness of people to do that because they are likewise thrust into the process for most purposes. But
a related question. So in my instance, there was a specific complaint made about one single meeting in 2014. But when the investigation went forward, it was expanded to go forward then to 2015, 2016 as well, even though that wasn't part of the complaint. To my knowledge, the commission never on its own motion decided to do that, so it must have been some internal decision to do that and expand this. So can you explain what happened there?
Sure. So typically what happens is when we initiate an investigation, we're basing it solely on the information that's come up in the initial complaint papers. And so during the course and scope of any investigation, you can learn any number of things as you're developing the facts and circumstances. And so under our statutes, we have the authority as staff, the executive director, so long as we provide notice and an opportunity to respond to the public, that our investigation has revealed facts and circumstances in addition to what we originally noticed, and that we're looking at all of these in the totality of circumstances as they relate to that investigation. So that's essentially an additional notice to that subject, that our investigation has revealed facts and circumstances that expand beyond what they were originally notified about.
But you would have had to have gone looking for those in this instance to find them.
Well, I don't know if that's fair. I think, our
There's
investigations
no way to know what happened in a 2015 meeting unless you go look in a 2015, look in all those meetings to find them.
I think that may be fair. We may have been looking at something in particular and come across those instances. I think investigations inherently, depending on how well done they are, bring up issues and facts and circumstances beyond what is originally proposed all the time. That's not something that was unique in any particular case. That's something, because we are relying on information that's brought forward from the public, our investigation has to be very in depth, because if, in most instances, and I will tell you, most instances, I'm trying to prove the opposite happened, right? I'm trying to see, what avenue do we have here, to show that this was not an intention. I want to know objectively what actually happened here. What's the totality of the circumstances? What is the picture I'm trying to paint to the commission in terms of any recommendation that I might be giving for resolution in a particular case? So, looking at the totality of circumstances, it would have prompted us to have been concerned about additional meetings to have noticed it.
Okay.
Any other questions? I'm done. Okay. Well, I think I will stop there. There's probably, we could talk about it for days, and I want to encourage you. I think the materials that you've been provided give you my contact information. That's my direct contact information. If you have questions, concerns you want to talk to me about, I'm happy to discuss those with you. Obviously your first line of contact is going to be your counsel. But certainly if you have those types of issues, you're concerned about bringing them forward, I'm happy to talk to you. The conversations that we have are maintained as confidential. So I honor that, particularly to the extent it could result in an advisory opinion. Just because you tell me of a circumstance does not mean I'm going to turn around and go to the commission and say, we should investigate this person. That's never happened. I wouldn't do that, and I would not dishonor, your coming to me on those issues for something like that. So now, probably don't come to me and told me you accepted a bribe, and please don't put me in that position. But I say that in jest. But I really do, want to thank you for your time today. I know it's scarce, and I know you guys have a lot on your plate, and I do appreciate what you're doing on behalf of the public, and serving in this capacity is not an easy thing. So also is it not easy to sit through 2 hours of ethics training, but I do appreciate your time, and I welcome the feedback always. The fact that we can get the ethics laws in better shape is always a goal of mine, particularly as we are going into a legislative session. So I appreciate your time. I welcome any questions you guys might have now or in the future. You have my contact information, and I appreciate it. So thank you.
Thank you.